disappeared already.
Good evening. Welcome to the meeting of the Skokie Village Board for Monday, December 4th, 2023. This evening, we will be led in the Pledge of Allegiance by our village clerk, Pramod Shah.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The meeting will come to order, and the clerk will please call the roll.
Trustee Sutker,
Here.
Trustee Robinson,
Here.
Trustee Kuhn,
Here.
Trustee Johnson,
Here.
Trustee Pure Slovan,
Here.
Trustee Klein,
Here.
Mayor Windus.
Here, we have a quorum. The next item on the agenda is approval of the consent agenda for this evening's meeting. A motion is in order. Trustee Pure Slovan, seconded by Trustee Johnson. Is there anything on the consent agenda anybody would like to have removed? If not, call the roll, please.
Trustee Sutker,
Aye.
Trustee Robinson,
Aye.
Trustee Kuhn,
Aye.
Trustee Johnson,
Aye.
Trustee Pure Slovan,
Aye.
Trustee Klein,
Aye.
Mayor Windus.
Aye, the motion passes. Before turning the meeting over to our village manager, I would like to make just a brief statement. Friday afternoon, the village received a public access opinion from the Public Access Bureau. It concerned action taken by the village board when it voted to approve the closed session meetings of June 5th, 2023, concerning a pending workers' compensation matter during its October 2nd, 2023 executive session. This board has been asked to correct this action by including the approval of the June 5th, 2023 closed session minutes at its next regular board meeting with a public recital of the action to be taken before the vote. In light of the fact that this opinion was received on Friday, after the agenda for this evening's meeting was published, this matter will be addressed at the next village board meeting. So if anybody is interested in the subject, the next board meeting, we will address this after we've had a chance to adequately review the public access opinion. Next item on the agenda is report of our village manager, John Lockerbie.
Thank you, Mayor Van Duzen and trustees, and good evening, everyone. Item A is regarding paid leave for all employees working for the village of Skokie. As of March 13th, 2023, Governor Pritzker signed into law the Paid Leave for All Workers Act. The law mandates that employees are entitled to a minimum of 40 hours of leave per year. Theoretically, under the act, an entire shift of police officers, firefighters, public works crews, or village hall staff could all request to be off work the same week or during an emergency response, such as a snowstorm. This law exempts park districts and school districts. Over the past several months, the councils of government, including the Northwest Municipal Conference, which Skokie belongs to, as well as the Illinois Municipal League, have advocated for municipalities and specifically to be exempt from this act. In addition, park districts and school districts, as well as municipalities, have well-established leave policies which appear to meet the #1 listed intent of the law, which states, establish a minimum paid leave standard for all workers in Illinois. Through the many conversations as municipalities advocated for consideration with the state legislators, it became evident there is some confusion about the law. One of the aspects that is causing confusion is whether existing leave provided by employers meets the standard of the act, or if a whole new leave type is required. Thus, municipalities then advocated, if municipalities cannot be exempt, then delay the effective date from January 1st to the summer of 2024. That also was not successful with the legislature in Springfield. Thus, the village is now in the position of either complying with the act or to exclude the village from this legislation. Municipalities are considering opting out of the legislation, for example, Buffalo Grove, Park Ridge, and Wilmette. In addition, a number of municipalities have already opted out. For example, Hoffman Estates, Lake Forest, Palatine, Schaumburg, and Winnetka. It is staff's recommendation to exclude the Village of Skokie as an employer from the coverage under the Paid Leave for All Workers Act. This is essential to ensure continuity of municipal services. I concur with staff's recommendation and respectfully request the mayor and board approval to authorize Corporation Council to draft the necessary ordinance.
A motion is in order. Trustee Sucker, seconded by Trustee Robinson. Let me just add one addition to what the manager said. It is the intention of the Illinois Municipal League and the Northwest Municipal Conference in the spring session of the legislature to go back to work on amending the act in order to give municipalities assurance that in case of emergencies, we would be safe and we would be secure. So, but as John just said, we have to make a decision this evening. If it's an affirmative decision, then we have to have a second reading because January 1st is the deadline by which we must have made a decision. So,
Question.
yes, of course.
What is our policy on sick leave right now?
So Deborah Stinson is our Director of Human Resources, and she's with us this evening and has been the point person on this, and she can answer the question.
Thank you.
Right now, we, for sick leave, our employees receive 12 days on an annual basis.
So so they already get the 5? 'Cause
Oh,
this
yeah,
is
our
5.
current benefit structure meets the standard that's established by the Paid Leave Workers Act.
Okay.
If you count all of our benefits, it more than meets, it exceeds.
Yeah, it
Thank you.
exceeds
PD.
the trustee Sucker.
Thank you all.
Sorry.
That's okay. So that means if somebody calls and says they're sick and they want to take a mental health day, they could take that day?
Today,
Yes,
Yes.
today with our current
yes,
benefits package.
if an employee wants to take a sick day, they can call in and say they're ill, and if they have the sick time available, then they'll be charged.
And that's the only reason they have to give, they don't have to give any details or,
Well, if they're talking about one day, most likely not. If they're talking about a week or two, then we may want to dig a little further because there are several reasons why we want to do that. One, of course, would be to determine whether or not this sick leave or this sick time is prolonged, and does the Family Medical Leave Act come into play
Yeah.
with regard to that? So,
okay.
Well, I'm sorry.
No, go ahead.
No, go on.
I'm just confused by this law. I've read it today and it doesn't, let's say right now I have 30 days of vacation time because I've been here at Skokie for a long time. And then, is it saying that 40 hours would be under this new rule where there wouldn't have to be a reason, and the rest would be, the rest of my time I would have to comply by the village rules? I
Well-
guess I'm confused.
yeah, I understand that. The way that it's structured now, and this isn't the final, so the way that I understand the way that it's constructed now is that if you would accrue under the Paid Leave Act, you would accrue 1 hour for every 40 hours that you work. Under the village's benefit program, you have sick time, you have vacation time, so you have different types of paid leave time that you could use, potentially use for your absence. So because the village's current benefit structure meets or exceeds the Paid Leave Workers Act, then we wouldn't be implementing that 40-hour piece. However, the final rules with regard to this have not yet been established, so that could change. But right now, it's my understanding that because the Village of Skokie meets or exceeds the requirements under the Paid Leave Act, then there wouldn't be any reason to implement that on top of the benefits that the village currently offers.
Okay,
So you would utilize your existing paid leave time for your absence.
Trustee Robinson?
I just have a couple questions. Thanks for being here tonight. So there's no sub bank or something like that, right? When people are out, people can come in to sub if there was a need because of the absences. I'm thinking like penalties for extended absences for staff
Today or under paid leave?
today, and if you can compare.
Okay,
Under
under
the law.
paid leave, you cannot, the employee is not subject to any adverse action for the use of their time. And today, if an employee calls in and they're sick, there's no adverse action administered against them for that today.
Right. Thank you.
So,
Trustee Purefoy?
thank you. So as I'm understanding this under the new, the proposed act from, Illinois, it's like an accrued time, correct?
Yes.
So personally, I will tell you that that's what I have in my day job. And, it doesn't, right, so if I've accrued, I cap out, and unless I take a sick day or unless I take a vacation day, I'm capped out on how many hours I could get. So it seems to me for employees, it's better to know that you have X amount of days and you can use it. We are exceeding what the requirements from the state are.
We are.
Okay, thank you.
and then one more. Oh, sorry.
Okay.
So the reason that we can opt out, I just want to make sure I understand this, sorry. The reason we can opt out is because of home rule, and that's why municipalities are, and doing that, and my follow-up on that question is, why did they exempt parks and school districts? What was their reasoning behind that and not municipalities? Did they have some kind of criteria that they looked at?
I was told by legislators, and I won't quote anybody in particular, but I was told by a couple legislators that they thought municipalities were included, and that the intention was for municipalities to be included with park district and school districts. Whether it was, whose error it was, municipalities were not in the legislation as it was finally passed. What happened in the veto session was only a couple days. And they were going to take up an amendment to include municipalities with park districts and library districts and so on. However, other units of government came in and said, what about us? And it just got overwhelming, and they couldn't get it through both chambers in time. And that's when we went to the alternate strategy of asking that they simply amend the law so that the effective date would not be January 1st, but would be July 1st, and give us the spring session to then finally settle the issue. They did not get it done.
Did they give reasons why they exempted the parks?
Oh, I mean, very much the same reason that John and Deborah have given. We are open to the public, and park districts and obviously the schools are open. And The idea is you need to be able to plan. One of the problems in the village, I think, is that we do have some small departments. Our building department is not gigantic. The manager's office, community affairs, the legal department. And so if all of a sudden, no collusion, I'm not talking about that, but you get 2 or 3 people calling in saying, I won't be in for a few days. All of a sudden, the department is strapped. Who is going to get the work done? We have administrative hearings and in the building department, we have to get permits issued and so on. So you could conceivably have a crisis, might be overly dramatic, but a substantial problem. Trustee Johnson, did you have a question?
I was gonna ask, one of the big questions for me is how this would apply to part-time employees, am I correct that that if we did comply with the Paid Leave for All Workers Act, that this would not grant any additional paid leave for full-time employees?
That is correct.
What about part-time? Would the Paid Leave for All Workers Act grant any additional paid leave to the village's part-time employees?
It would.
Can you explain, I guess, what would change?
Yes, right now, today, our part-time employees receive holiday pay if they work on the designated holiday and the village is closed, then they would be paid. They also receive 3 floating holidays a year that they can use at their own discretion, however they want to use it, provided it doesn't impede the operations of their department.
But the Paid Leave for All Workers Act would still be above that minimum? that we have?
Yeah,
Okay.
because it's 40 hours today.
If we do not opt out, do we have any sense of what the cost will be to the village?
If we don't opt out, I don't have that information in front of me right now. John, do you have that?
I do, I have
Okay.
it. So to the village, so the village's part-time employees, there's about 28 out of our 450 employees, just for some context. And so currently, some of the part-timers are summer employees. And so a lot of them are at college, and then they come and work their summers with us and help us with influxes of activity, whether it's in Public Works or the finance front counter, et cetera. And so what this new law act would cause is for those employees, as well as the other part-time employees, to then receive whatever vacation they have accrued, 1 hour per 40 hours of work. And then if they have not taken that vacation time, their last paycheck will now be paying out for that additional benefit. And so in the situation for the last 12 months, the value of this unfunded mandate from the state of Illinois is $15,109 for the village of Skokie. So if we may have had to hire, if these employees took the additional time, then we may have had to hire overtime in order to cover it. Assuming that we didn't hire any overtime to cover the work, and these employees did not take the vacation time, it would cost the village $15,100 in additional payout to employees. And then from a full-time basis, if the interpretation of the act is that it is above and beyond what currently exists, so it's an additional bucket created of leave, then that cost for the village, again, for about 450 full-time employees, it comes to $1.21 million per year. And so that's if the interpretation is that existing leave does not meet the act and there has to be an additional leave created.
Sorry. So I want to make sure now, because I'm getting
Yeah.
confused again. So you're saying that but because we are already above what the act is, we wouldn't have to worry about that 1 million?
There's different interpretations, and so I don't want to confuse the topic. I do feel strongly that it's in the village's best interest for the village of Skokie to not be applicable to the state statute because of all these questions and unknowns. And for years, we have put in place benefits leave included with procedures so that we can maintain operations and serve the public, but also be very mindful of the needs of our employees. And so we've balanced really what's in the best interest of everyone. And now the state is saying, we think we know better, and you need to do this. But as I sit here today, I can't tell you exactly how it's gonna roll out, because there's public comment period on the rules and regulations through the middle of December. And so until those are finalized, and so many attorneys are interpreting the way the state statute reads, that the village's current leave is sufficient. But there are people that have been involved downstate in Springfield representing the municipal interests that understand that a new bucket of leave has to be created. And as I sit here today, I can't tell you which way is right, but I'm concerned that we're losing control by having to follow the state act and whatever rules are established at the state level.
The only thing just to add to this, which is obvious, I think, but bears at least stating, this board can take whatever action it wants during the budgetary process in addressing whatever issues in terms of leave and so forth that are worked out with the village manager and staff. So you're not foreclosed from doing whatever you feel you need to do for the employees of this village. It just does not have to be suddenly, not weighing in either way, but I'm just saying, one doesn't have to think that if you don't embrace this proposal, where for the first time the state is trying to instruct on these issues of leave and salary and so forth, you're not foreclosed from doing whatever you think in the process of your work, generally addressing employees and employees' compensation, and you couldn't take care of it within the confines of the village, rather than acquiescing in this situation. You would concur, I assume?
Right, as long as the village opts out of the January 1st deadline.
Right.
Just to be clear.
I think for me, I think like a lot of you, I've been confused by the language in this act, and also kind of the question of what is in this act versus what is being contemplated as a potential amendment theoretically in spring. But at least from my reading, because it seems like other municipalities have addressed this question of the possibility of a crisis, or what happens if lots of police officers, firefighters wanted to take off at the same time. I guess my reading of this act is that this act still provides employers with the flexibility to set policies and procedures on how employees give notice of when they want to take time off, and also the ability for employers to deny an employee's request if the employer provides services that are critical to health and safety and welfare, like first responders. So I guess, yeah.
So one other layer of complexity that should be mentioned is collective bargaining agreements.
Right.
And so how does this act get related to collective bargaining agreements? You know, currently we have collective bargaining agreements in place with our unionized employees. But when those agreements are time for renewal, how does this issue get contemplated and resolved in those issues? And so, again, if the municipality is giving up control and saying we're going to abide by a state statute, it's adding another level of, the village doesn't control everything.
Yeah.
I have a follow-up question regarding the part-time workers. Deborah, if I'm trying to understand this, picking an arbitrary number, but let's say someone's part-time working 20 hours, equivalent of 20 hours a week. Today, during our current leave policy, they automatically get 3 designated floating holidays without accrual, whereas with the Paid Leave Act, it would be through accrual that they would acquire those, let's say, 20 paid leave hours. And then we're also paying holiday time on top of that as well. They're working on a holiday. So in that particular situation, our current policy, even for part-time workers, is better than what is proposed by the Paid Leave Act.
Yes, the only reason I said not necessarily is because it's based upon the value of the day.
Right, okay. Okay.
I would like to just, if I can make just kind of one argument for the board's consideration, because this question of kind of control and, has come up. And I totally respect that in aspects of the village determining the impact of these decisions on village operations, I totally understand why the village would want to maintain that full control. But from my understanding, you know, the intent of this act is to really give some control back to employees statewide about how they make their paid leave decisions, and to make it a lot easier for someone to take leave off for a mental health day, or because they need to take care of a sick kid or a family member, or because they're just going through any kind of random life crisis. And I think that kind of flexibility, that kind of control, I respect the intent of this act, even if I totally agree with a lot of you that what we have here is confusing.
Well, but I respect that, and I think that's one of the reasons this is such a difficult piece of legislation. But the village has always made it its policy to try and be on the generous side with our employees. I mean, the idea is we serve the public. We want our employees to be happy, to want to work here. Many of you have gone to the going away parties. It is not unusual for us to have people work for us for 25, 30, 35, in a few instances, as long as even 40. And I think there was one who was with us 45 years. And I think part of that is because we have been very conscious of that. And I don't know that there is any great benefit to be derived from the act for our particular employees. I could see where in private business that there might be a problem, particularly like the fast food industry, for example. That's one of the examples that is given for the legislature passing the act. I think the legislature thought that it was including municipalities. Some of them seemed pretty surprised when it was pointed out that municipalities were not included in the act. And I think if you look at the list of the municipalities that have opted out, you will see that, like the village of Skokie, they're good. They treat their employees fair and equitably. But like I said before, some of our departments are relatively small, and if all of a sudden we can't plan who is going to take off a week here, a week there, it could cripple our service. Enough said by me.
I appreciate that feedback, because I agree with you that it doesn't seem like we are not the target of this legislation. Our employee
No, I
packages
don't
are
think
pretty
so.
outstanding.
I would add that because we're not the target, and because like John said, there's some confusing parts of this law that are not worked out yet, I think it would be better to opt out and then wait and see how,
I
and
agree.
know that we have done what's best for our village of employees.
I agree. I think that's convinced me. Yeah.
Call the roll, please.
Trustee Sutker,
Aye.
trustee
Oh,
Robinson,
wait. I'm sorry. I thought go ahead. No, you have to come to the microphone.
I'm
May we
sorry.
have your name, please?
Hillary Hunter.
Okay, thank you.
Okay, couple of things. First of all, and I don't want to sound immodest, I've negotiated contracts for the state of Illinois for 150,000 employees on behalf of AFSCME with the team. So I'm a little bit familiar with this. I'm not an expert. I haven't read the law. I find it very interesting that we're going to vote on something when we don't know exactly how it's going to fall out, what it's going to be. you said there's more discussion open and they're gonna revise it and you don't really know how it's gonna look. There's a lot of ways that, so I hear that part, and then I hear the part about what happens if everybody in a certain small department calls off on the same day. So, for example, for Illinois State employees, for popular days, like the day before or after Memorial Day, Christmas, before Christmas, whatever, people at first of the year have to all put in their requests for time. And there's only a certain number of people who will get approved. If someone calls in 2 days before Christmas and says, I'm sick for 2 days with the flu, the employer then has the right to say that will be unpaid because that's a popular time and we were counting on you to be part of the skeleton crew, and I'm sorry, but you did not request it at the beginning of the year. And some places use seniority, places rotate it every year, whatever. There's ways to handle that, I guess. I'm just not sure what the difference is between how we are doing things right now in terms of preventing, let's say, a small department like the building department all calling off on one day, and how this law is going to change that. And I don't think it's a good policy for us to just be reactive, like we don't want them to tell us what to do, because I think we should save our nose for when it's really important to the state. We shouldn't always be like reactive and just kind of negative. I really don't understand
We're not being
the difference.
reactive. We are not being reactive.
Okay, explain to me then, please.
Because the act becomes effective January 1st. We either act or we don't act. And we have first reading, and then we have second reading. We must get it done in December. The legislature took this up in the veto session and did not act. So it then fell to us. In the meantime, the Illinois Department of Labor, and I'm not criticizing them because they're doing their job, but they opened a public comment period. That comment period will not end until shortly before Christmas. So if we don't act, and the Department of Labor comes up with rules and regulations that tend toward what our interests in Springfield fear, then we're caught, because we can't do anything.
After it's passed, we cannot have that.
January 1st is the date, period. So we're not being reactive, we're doing what we must do
Proactive, you're saying, is how
according
you
to
see
the
it.
law.
But, so we already give people this leave, we already have some procedures, I'm sure, this woman's very smart, and I'm sure you have a good contract. You have a procedure for who gets time off, when.
Let me add a little
I
bit
don't
of,
understand how this is I really don't understand. You haven't been able to show me the parts that are dangerous. I'm gonna sit
so,
down. Go
so
ahead.
let me just, Mayor, if I could, just
Of
add a
course.
little bit of explanation about leave as it relates to emergency situations. So during COVID, there were many facilities in town that had wings that were 100% COVID positive individuals. Our firefighters were daily going into those wards, addressing the needs of those residents and getting them to the hospital if necessary, or handling whatever that situation presented. If those individual firefighters were calling in because there's less regulations, they were in very stressful situations, and they had to, whatever they dealt with at work, they had to go home to whatever they have at home. Those are very challenging situations on both fronts, but they did an admirable job, and they were dedicated to the community, and they provided outstanding service, outstanding job, but very stressful situations. But if the employees, by state regulations, have less obligations in order to take time off, for example, a snowstorm. A few years ago, we had about 22 inches of snow in town. And so we needed village employees, the public works plow drivers, the police officers to handle car accidents, the firefighters to respond to different situations. We also needed staff here at the village hall and in public works to be able to respond to citizens that were calling, not to mention the 911 center. And so when employees then start to have the ability to not come to work because on the day of, there's less obligation to come to work because they're not following the regulations, because bereavement leave, for example. We have bereavement leave, but in certain situations, you can increase the amount of bereavement leave. And so the village has policies in place, so we sustain operations, but we also are employee-friendly and can take into consideration special circumstances. But the emergency situations and the need to provide a variety of services really is incorporated into all of our policies for leave, and it's important that we maintain that integrity.
Yes, go ahead.
Matt Jarvis, Skokie resident. The optics would look amazing if we, I think agreed with this state act. I understand the confusion around it. Is there a way to implement a sunset on this after a year so that we'll know when the spirit of the law meets the actual rules enforcing it?
My understanding is that the exemption needs to occur before January 1st, and so I don't know that there's a way to meet that obligation and also have a sunset.
So like after a year to have, force a revisitation?
If, the village could always have that opportunity, but to force a visitation with a sunset clause where it's sunsetting on this date unless the board would take another action, I don't think that works with the January 1st obligation. I think the village board always has the ability to revisit the topic.
Just one final question. I might not be the only person thinking this, but does anyone have an answer of why the state has given us till January 1st to opt in or out, but has not finalized the language? It is not going to finalize the language until March or April?
Welcome to my life.
You stated the obvious.
Well, Allison, you operate in Springfield.
Yeah.
I mean, you have two bodies in the legislature, plus you have the governor's office. And they're not always rowing in the same direction, I'm afraid. Sometimes you can see what the product is.
Mayor should point out again, we did reach out, you reached out to our elected reps, and they had no better answer for us. So.
Yes.
They gave us 10 days for assault.
Okay, we were in the middle of the vote. Please resume the vote.
Trustee Sutker.
Excuse me, the vote is to opt out, correct?
Correct.
Yeah.
Thank you.
Aye.
Trustee Robinson.
Aye.
Trustee Kuhn.
Aye.
Trustee Johnson.
How about aye?
Trustee Pure Slovin.
Aye.
Trustee Klein.
Aye.
Mayor Van Dusen.
Aye, the motion passes.
That completes my report this evening.
Thank you. Next item is report of our Corporation Counsel, Michael Lorch.
Thank you, Mayor, trustees, good evening, everyone. Items A, B, C, D, and E are ordinances from my Corporation Counsel report that were part of the consent agenda at the beginning of this meeting tonight, and they were adopted at that time. Item F is an ordinance on the agenda for second reading and adoption. The first reading was on November 6th, 2023. At the November 2022 Illinois general election, Skokie residents approved 3 citizen-initiated referendums to change the village elections to nonpartisan, staggered terms for trustees, and establish hybrid districts in 4 geographic areas. To assist with the implementation, the firm of Klein, Thorpe, and Jenkins was approved by this board, and they drafted ordinances for this purpose to enact what was passed in the referendums. And we have attached the memorandums that were previously attached to village minutes, and they set forth the details of this information. And Mayor, we would be asking for board action on these ordinances tonight.
A motion is in order. Trustee Johnson, seconded by Trustee Sucker. After all of this time, are there any comments or questions remaining? If not,
Well, I think there might be comments from the public too, but, I just wanted to, we talked about this a little bit during the first reading. I just want to give kind of another plug for for the possibility of ranked choice voting. This is something that has been discussed to deal with the potential of increased primary elections due to our new electoral system. I think you all know how big of an advocate I am of our new system. But I do acknowledge that I think the greatest lingering flaw in the new system is the possibility of unnecessary primary elections. And I think there was a resounding agreement from the board last year that we don't want more elections. In the new system, well, I think I should also say, under our current system, we could have a primary election. We actually did have a Skokie primary election in 1977. But these electoral reforms will inevitably increase the likelihood of an unnecessary primary election. It could, anytime there are more than 4 candidates for any seat on a village ballot, it could force a local primary. This could happen in 2025, it could happen in 2027, 29. But I think the likelihood is that it will happen eventually. We have the power to prevent this. We can do exactly what the city of Evanston did last year. And we can replace primary elections with something even better, a ranked choice voting system. The Evanston City Council put this on their ballot last November, and it received over 80% of support from Evanston voters. It was a slam dunk. If we did this in Skokie, it could make our new system, I think, even better. So I want to just throw this out to the board as something to contemplate. This is something we have the power to do. We have the power to put a referendum on the ballot next year, or really any time in the future, to replace primary elections with ranked choice voting. If there is any support for this measure, I ask, please, board members to reach out to me, and I would be more than happy to get an agenda item on our agenda, write a memo, do anything to kind of spell this out. But if we do want to take action to avoid unnecessary primary elections in the future, we can. This is something the board can take action on. That being said, I do think our new system is a vast improvement over our old system, and I'm a big fan.
Mayor, I just want to say, I just want to vote on it as it's written. This is what was voted on. This is what the community wants, and that's at this point.
Oh, absolutely. I'm not
the
suggesting
most
anything new
respectful way.
tonight.
Okay.
Absolutely. I'm not suggesting anything new. I'm just, this was a concern that was brought up in our first reading about how our new system could lead to primary elections.
I just want to thank the village manager and everybody involved in the process for this. I think it was really well done, so thank you.
And I will say, and again, I think the biggest thanks goes to the voters of Skokie. These are voter-initiated reforms. The thanks, the work, this is the people of Skokie doing this work. Thank you.
Call the roll.
Trustee Sutker.
Aye.
Trustee Robinson.
Aye.
Trustee Kuhn.
Aye.
Trustee Johnson.
Aye.
Trustee Pure Slovan.
Aye.
Trustee Klein.
Aye.
Mayor Winderson.
Aye, the motion passes. An item of new business.
During new business, I was going to bring up the determination letter from the AG's office that you mentioned at the beginning of the meeting. I will just clarify, Mayor, you did say that we were going to talk about this at our next meeting, or this was going to come up. Will the closed session minutes be on our consent agenda, or will it? Yeah.
What I wanted to do is take a look at it, review it, and talk to a few people.
Okay.
So I will wait and see. I don't know. I have no hostility to the idea, let me put it that way. As I think anybody would expect, I want to give it some thought and read and reread and reread the opinion and see what the implications are, that's all.
Okay. I was just going to make a formal agenda item request to put these closed session minutes on our next meeting agenda. At least from my reading of this determination letter, this fix is pretty simple. It's not a super complicated problem. It's really just making sure that we approve our closed session minutes on our public agendas. I guess what
Well, I do have some questions that I want to try and get answered. So I would just ask everybody, let's be a little patient. We've gotten the decision. The decision does outline what action they're asking us to take. And as I've said, I don't have any hostility toward this. Just, I want to think it through, that's all.
Respectful.
I just think that's, being a little thoughtful, I think, is good.
Were you gonna say something?
Yeah, I also wanna review it and,
Okay.
I mean, there are some things in it that I have put some questions about, and then there's an option in there too that I think I need to take the time to understand it and read it through and.
The only reason I'm pressing this is because it is a binding determination, and the determination does direct us to take action at our next meeting, which would be December 18th. The last time we got a written determination letter from the HE's office related to our OMA violations, we did not act in time.
It wasn't a binding. This is the first binding determination.
I
we have
agree.
received.
I would argue that makes this even more serious that we,
Well,
that we,
right.
act in time.
Nobody's arguing that point.
And no one's suggesting, we're just asking for more time to review it. We just received it, and I wouldn't be comfortable either commenting on it. So I think we need the time till December 18th, and we ask you to respect that. No one's not taking it onto the agenda December 18th, we just need the time.
It will be on the agenda.
Okay, if it's on the agenda, that's good enough for me. Thank you.
It will be. That's what I said in my opening statement. Next item on the agenda is Plan Commission Case 2023-29P. Site plan approval, 9230 Lotus Avenue.
Thank you. Good evening, Mayor and members of the board. At the October 19th meeting of the Plan Commission, we heard a request from Orchard Village for a parking determination and site plan approval for a congregate living facility for primary residential use in an R2 single-family residential district. The applicant for this project, Orchard Village, proposes to occupy a residential home at 9230 Lotus and establish a 6-bedroom group home under the congregate integrated living arrangement license with the state of Illinois Department of Human Services. Under state and Illinois Administrative Code, the maximum number of residents at this home would be 8. Orchard Village proposes a living arrangement with a maximum of 6 people. In furtherance of the review of this request, the Plan Commission recommended by vote of 5 ayes and no nays to, to recommend to the village board approval of the site plan approval for the Scylla home with a maximum of 6 residents. Additionally, the Plan Commission reviewed the applicant's request for parking determination, and it was determined that the site would have 6 off-street parking spaces. Under section 118.95F, governing the village special use regulations applying to this project, A, congregate living facilities may be in a residential type otherwise identified as permanent or special use in the district. B, no residential unit shall be permitted on the first floor in business or mixed-use districts. C, the facility shall be a permitted use if the sponsoring agency is eligible for and obtains a state licensing or certification to operate the proposed site and used as a permanent residential facility. D, the facility shall be designated a permanent resident facility for all residents intended to live at the facility for 1 year or more. Any facility with more than 4 bedrooms as a residential unit, 2 or more residentials in the building, or 2 or more buildings in a lot or abutting lots operated by the sponsoring agency must receive site plan approval in accordance with Article 2 of this chapter. The sponsoring agency must obtain an administrative occupancy permit prior to establishing a congregate living facility. The following criteria will be used to issue a permit. The facility must be located in an area reasonable, accessible to public transportation, and if needed, employment, vocational medical, psychiatric, recreational, and other community resources that might be utilized by the facility's residents. If this provision cannot be met, the sponsoring agency must ensure that the facility's residents have access to the service when needed. Except as allowed in this section, the facility shall not be located within the same block or as another such facility, nor closer to 800 feet to another facility as measured from the property line and for the for the lot, for the property line of the lot.
A motion is in order, trustee Johnson, seconded by trustee Pure-Slovan. Are there any comments or questions?
Just
Trustee Khan.
There's a couple questions. I'm just asking, going by sight. It is an R2, it is not an R1 district?
I believe
Unloaded?
that's what it is. It's an R2 there.
Okay, just from sight, I don't have any, reference, just going by sight. And is there public transportation in this area that I'm not familiar with?
Not really, but they're gonna have a caretaker there with a van or a vehicle to transport the 6 residents.
Okay, now just going by what you
Yeah.
were saying, that they had to have public.
Well, or the facilitator has to supply transportation.
Oh, okay. Thank you.
Trustee Robinson.
I was just gonna ask about ADA accessibility and curve cuttings and any of that needs to.
Well, it's interesting in that this house was preoccupied by a World War II veteran, and everything in the house was ADA.
Wow.
Sir, did you?
I'm sorry.
Oh, I'm sorry. Excuse me, trustee Sucker.
So, Orchard Village has other places in the community,
Yes, they do.
and it's my understanding that there's never been any problems at any of
None
these
that I'm aware of.
facilities or any kind of issues. I know
No.
I read some of the comments, and I just wanted to make that clear that we have these other homes and there's never been any kind of problems with safety or police or anything like
Again,
that.
none that I'm aware of.
Okay, thank you.
Did you want to address the board? Yes. Everybody gets 3 minutes to address the board if you wish.
My name is Dean Rauschwerger. I'm the adjoining property owner on Lotus. Our house has been on the street for approximately 100 years. We're one of the oldest homes in Skokie. Lotus is one of the oldest homes. We appeared, the community, the neighborhood appeared October 19th in front of the Planning Commission. And out of that hearing and from what transpired from before, there's some serious problems and some serious red flags. This is what Chairman Lukey said at the hearing, and it's recorded. This is a done deal. Our hands are tied. The regulations are trumped. Again, basically, our hands are tied. That is a serious problem. It appears to be, it raises serious questions. The process has not been investigated and evaluated. Why do I say that? When this originally issue arose, I went to the Community Development Agency and met with Paul Rice. I asked him what the regulations were. He said he didn't know. That's a problem. How could he not know, if you're supposed to be knowledgeable and qualified, what the applicable regulations, the ordinances are, the rules of the road? Didn't know, it's a red flag. When we appeared before the commission, they weren't aware there was another group home a block away. Even though it may be more than 800 feet, they had no knowledge. It wasn't until one of the neighbors raised awareness that there was another group home. The regulations are being ignored, and it's been an abdication of responsibility. What do the regulations say? It's important, because the regulations speak to, it must not appreciably alter the characteristics of the neighborhood. What are we talking about? A huge density increase. At that home, there was 1 to 2 residents. On the street of Lotus, most of the density is 1 to 2 residents. This home will now become a dormitory. It will be multifamily, congregate living, and the bottom line is, it's the wrong location. It alters the characteristics of the neighborhood by increasing the density of the home, okay? It's a quiet street. Separately, in the regulation, for which cannot be ignored, it is the controlling rule. They are not trumped. The regulations use the word isolating at least 4 times. So the impact to residents is access to mass transit, a fundamental concern. The nearest bus stop is on Golf and Central, almost a mile away. The next nearest bus stop is on Dempster, almost a mile away. Now, while you may say you can mitigate that with van service, the residents will become dependent. They will become a prisoner of the agency. They don't have access to walk up and down Oakton Street, integrate them into the community, go to the library, go to Village Hall. They are suddenly becoming prisoner of the home. So if we are concerned, certainly this property to the residents, will it be isolating? It absolutely will be.
Okay, sir,
Excuse me.
3 minutes are up.
I understand. Okay, when I raised, matter of fact, I want to say something. When I raised at the Planning Commission why they were limiting us in time, and they gave the applicant unlimited time, Chairman Lukey says, well, she's paying an application fee. That's probably the last fee they'll pay since the property will be tax exempt. Us taxpayers don't have an opportunity to be heard. I raised this issue with you, Mr. Mayor, when we appeared last Monday, November 20th, and you said you'd look into it. So a very important factor, before this got approved, Orchard Village, and we're not against Orchard Village. It's wonderful. They're doing noble work, good work. We support them. It's the location. They were doing construction work 7 days a week before they got approval. That's a red flag. Who gave them
sir.
the green light? So who gave them the
Sir,
thumbs
your
up
time
to
is up.
proceed?
Your time is up.
But I want to know,
Thank
did
you.
anyone look into the regulations when they're in the process to know where the nearest group home was located, what the density is, and importantly, Chairman, the people in the commission said, all we're concerned about is the number of cars and the exterior facade of the house. That ignores, and Mayor, please, that ignores the regulation that says it cannot appreciably alter the characteristics of the neighborhood. You are essentially putting a dormitory, multi-family home
Sir.
in a single-family
Thank you.
area.
Thank you.
Do you feel, am I raising important concerns?
Thank you very much, yes.
But I'd like to ask you, Mayor, am
Thank
I
you.
raising legitimate concerns?
Thank you, sir. Thank you very much.
The community felt marginalized and discounted, and it's disappointing. Important.
Understood.
Concerns, red flags.
Thank you very much,
Feel
sir.
marginalized.
Sir, thank you.
If I may at this point,
Others may wish to speak.
Other, sir,
before
please have a
that,
seat.
I want to read something from the Fair Housing Act. The Fair Housing Act makes it unlawful to utilize land policies or actions that treat groups of persons with disabilities less favorably than groups of non-disabled persons. Example would be an ordinance prohibiting housing for persons with disabilities or specific type of disabilities, such as mental illness, from locating in a particular area while allowing other groups of unrelated individuals to live together in that area. Also, to take action against or deny a permit for a home because of a disability or individuals who live or would live there. An example would be denying a building permit for a home because it was intended to provide housing for persons with mental retardation. It's also unlawful to refuse to make reasonable accommodations in land use and zoning policies and procedures where such accommodations may be necessary to afford persons or groups of persons with disabilities an equal opportunity to use and enjoy the housing. What constitutes reasonable accommodation is a case-by-case determination. The term group home does not have a specific legal meaning. In this statement, the term group home refers to housing occupied by groups of unrelated individuals with disabilities. Sometimes, but not always, housing is provided by an organization that also offers various services for individuals with disabilities living in group homes. Sometimes in this group home operator, rather than the individuals who live in a home, they interact with local government in seeking permits and making requests for reasonable accommodations on behalf of these individuals. So, under the Fair Housing Act, again, maybe I said our hands are tied, but basically they are, that these group homes are allowable in that, on that street of Lotus.
My name is Shelley Pack. I live at 4235 Payne Street, across the street from an Orchard Village home that's on 9701 Trip. And I wanted to share with the village board and with the Lotus Avenue residents that the residents of that home are perfectly good neighbors. In fact, there is absolutely no difference between the Orchard Village residents and any other of the many large families living in my neighborhood. I'm disappointed and saddened to hear some of the comments made by the Lotus Avenue neighbors about Orchard Village. I read the ones that were made at the Plan Commission meeting and the comment that was just made here tonight. People who have disabilities have the same rights to live in our community as anyone else and shouldn't be the targets of discrimination or exclusion due to their abilities. If an individual homeowner had applied for a zoning change, I can't imagine coming to a village board meeting and hearing neighbors discussing the personal characteristics of the homeowner or their family. The fact that the people who receive support through Orchard Village have disabilities should be no different. As a longtime resident of Skokie, I am so proud of the work that Orchard Village does to provide much needed support and access to housing to those in our community who don't have many other options. I'm proud that the village has consistently supported Orchard Village and upheld the basic human right of expanding housing access, and I hope that tonight the village board approves the current project and continues to support the development of housing for people with disabilities in Skokie.
Please. Yay or nay, please. I thought, sir, did you want to speak? Okay, well, I thought you were next. Okay, very
He
good.
told
I
me to
just-
go in front.
No, that's okay. Just want to make sure everybody.
My name is Lauren Grodnicki. I was not planning to talk on this topic tonight, but I do want to share support for this home, and I do not think that the residents there are going to be trapped. It is not that far from the mall. It is not that far from the Forest Preserve. It is very close to plenty of places that you can walk, and I say this because there's a person who, I don't know if he was living in one of the Orchard Village group homes, but I frequently would pass him when I was walking around with my son back when he was still in a stroller. And I got to know him by face. He works at Home Depot and he lives north of Timber Ridge and he walks there back and forth. So not having your own car is not an impediment. I know somebody who does not live in an Old Orchard home. He's a member of Go Green Skokie and he walks everywhere. Like he lives on Howard and he walked to my house north of Dempster. Like he just walks, right? There's no reason that walking a mile is prohibitive. Thank you.
Thank you. Yes, sir.
So my name is Stephen Anderson. I live on the other side of 9230 Lotus. My grandfather bought the property. My father built the house. I grew up there. My son lives there, and my grandson lives there. So when I see Orchard Village, I see a house that is basically perfect for what they want to use it for. Being a friend of the neighbor, I've been in that house many times, and it was built for a World War II veteran, and it was ADA compliant. And I don't think Dean has said anything against Orchard Village. I don't think Dean has said anything against the Fair Housing Act. I think Dean has just brought up the facts of the street and the facts of the area. I don't think we're saying anything bad against Orchard Village. I think it's it's our thoughts that it is not a great location. It's a great house, believe me, it's an awesome house, and I can see why they bought it. But the location for a group of 6 women, the woman that was up here previously said, well, it was a man that was walking, you know, to his job and back. And I can see that the people in that house will be relying on that van more than they're gonna be using public transportation or even walking to work. So I've got a grandson that's living there. I see this van. This is not a family of 2 adults and 4 children. This is a family, a group home of 6 adults. And those adults have different needs than children do. And that is transportation to and from their job. And I guess my concern is this house gonna turn into a bus stop? Because if it is, I worry about the safety of my grandson.
Thank you, Mr. Anderson.
Hi, I'm Gail Schechter at 9033 B Keating, and I'm speaking, actually, I did think also that I was going to speak tonight, but but I've been involved in fair housing enforcement, as you know, for about 30 years. I've spoken before this board about group homes in the past. So I again would, I echo others who would support the village in supporting this application. And I just wanted to add one other piece of information that was not shared earlier, and that was the implication that a group home is multi-family housing. And under fair housing law, a group home is considered a family. And if that house, I think what we heard from Chairman Luke was that it has a capacity for 8, it would have 6. This is a family, this is how we should be looking at it. I also wanted to address the other point that was made about, you know, we don't know the group homes that are in existence. That's actually the idea. They're supposed to blend in, and you're not supposed to know where they are, because they are just another home with a family. So thank you very much for the recommendation and for your vote tonight. Thank you.
Thank you.
May I add that the home that the gentleman referred to that we did not know about is actually in Morton Grove.
Hi, I'm Carrie Brodan, a Skokie resident. Gail, you read my mind. I've been sitting here thinking that I had no idea that less than a block from me was a group home until I was out knocking on doors in the November campaign last year, and I discovered a group home less than a block from me. I've lived there a decade. I feel bad that I didn't know that many of my neighbors. Now I do. They're lovely. It's another family home on the block, just like every other family home on the block. I had no idea.
Thank you. Yes, sir. No, please come to the microphone so we can all hear you. Thank you.
My name is Steve Foley, and I live by the other group home, and you had mentioned that's in Morton Grove?
Yes.
I find it hard to believe because I live a half a block away from that place. And I believe that side of the street is Skokie, the other side is Morton Grove.
I was told it was Morton Grove.
9423 is not Morton Grove.
Okay.
And again, my concern that I had last time was, you mentioned last time that they had taken care of the parking, the bus will come. But by my house, when the bus comes to pick them up for transportation, there's nowhere to park. I gotta go all around the block. And then they said, oh, take it up to the enforcement board. The garbage behind that house, and I don't blame the people that live there, I really do not. It's the daycare people. There is so much garbage behind that house. It's not the people who live there, it's the daycare people taking care of them. And that's all I have to say.
Thank you. Any other comment? If not, call the roll, please.
Trustee Sutker,
Aye.
Trustee Robinson,
Aye.
Trustee Kuhn,
Aye.
Trustee Johnson,
Aye.
Trustee Pure Slovan,
Aye.
Trustee Klein.
Aye.
Mayor Van Dusen.
Aye, the motion
That
passes.
concludes my report.
Thank you. The concluding item on the agenda this evening is public comment. Is there anybody who wishes to address the board?
None?
Guess I beat everybody else up. I don't have anything of terrible substance, but I just, this is Matt Jarvis again, in case I needed to reiterate who I was. I just wanted to congratulate the board on passing this ordinance for the electoral reforms. You know, it was a lot of campaigning and a lot of tough feelings behind it on both sides, and kudos where kudos is due. You know, you guys did a great job, and I really appreciate what you've done here. Thank you.
You're welcome. Thank you.
Good evening, I'm Jan Bellotti, Skokie resident. I know you guys have talked since last year about the affordable housing issue, and I know nothing has really happened, and I really want to encourage you guys to take it up in the near future, because I feel it's really important. A lot of other towns in the area have been working on it and have been very successful. And I think we've talked about how some builders don't like that it's not beneficial, but I think it's an issue that is really important, not just in Skokie, but all over the country. And I really have concerns why nothing has moved forward. And I really hope we do something in the new year, especially the Old Orchard Mall. You know, we don't need another high-rise just for really rich people. We need a Skokie that is for everybody. So I really encourage you all to take this up seriously. Thank you.
Thank you.
Hi, I'm Emmy Yamauchi, also a Skokie resident. I just want to echo what the previous speaker said. I hope that the inclusionary zoning ordinance will not fall off the radar screen. I hope that it's going to be brought up again in the near future, hopefully with some positive revisions. Secondly, since my condo board's annual meeting is coming up tomorrow, and we live across from the Homewood Suites skeleton, I'm just wondering if there's any update on Homewood Suites.
People that are involved in the project continue to work towards a solution. I don't have a specific solution to report at this time, but there continues to be a lot of work on a number of parties in order to get it moving forward.
Is the village involved, though?
We have been involved, yes.
Okay, and is there a, I don't know what you would call it, an expiration date on the obligation of that $4.5 million loan?
There was not a specific date, but the requirement was for there to be a total solution. So the village has not funded any dollars of that. It was part of a total solution.
Okay, but in the meantime, nobody else can apply for grant. I mean, that $4.5 million is obligated, not used, I mean, not spent, but it is obligated. It can't be touched by anybody else who might want a loan or a grant.
It's designated for the hotel project.
Right, okay, so it's obligated. Thank you.
Just a sec. In my continuing series of let's enforce the laws that are on the books, let's talk about poop. So this is a problem. I want to tell you a story. A week or so ago, I was taking my daughter to school, and there was a bag, a ripped open bag of dog poo right outside the fence opening to the blacktop of the school. Like, if the kids came out for PE or recess, they were going to see this bag. And little kids are curious and they like to play with things. It's a public health problem, right? Unwitting children or adults can walk through it. Curious children might, and I've known children who were that kind of kid, play with it, right? Like, let's not have dog poo lying around. It is officially a village code issue, right? Removal of feces shall be deemed a public nuisance for any person to cause or permit any dog owned, controlled, or kept by such person to defecate upon any public street, sidewalk, or other public place, or upon any other premises not owned or controlled by the person owning, controlling, or keeping the dog. However, any person owning, controlling, or keeping a dog who promptly and completely removes such defecation shall not be considered in violation of this section. It's posted pretty clearly everywhere, and in case you can't read English, it doesn't matter because the picture's pretty clear, right? So, useful information, right? And I started off with a problem, I'm going to get to a solution. There's DNA in poo, and it's actually not very expensive to get one of these forensic machines and then sample the poo, right? We can do this. Other municipalities are already doing it. And not all of them are municipalities. There's a housing company that owns properties in a handful of states that actually does this. So here's what I'm proposing. We get one of these $2,500 machines. When a resident registers their dog, you require a DNA sample, right? Just like you have the address and everything of the person, right? Get the DNA. Computer space is dirt cheap at this point. Sequence the DNA. Encourage residents to call about the poo because, I mean, I'm not suggesting that the village goes around looking for it, right? But when someone calls about it, you come, you sample it, you know whose dog it was, and you go find them. And you make a change to the village code, because right now I think it says that fines can't be over $750. Have this be an increasing thing, because fines usually are seen as like a fee of convenience, right? If I can afford it, I might as well do it, if the chance of me getting fined is low. But the first fine, $500. The second one would be $1,000. The third one would be $2,000. It very quickly becomes not worth it to have that convenience of just leaving your dog's poo around. So please consider something like this. Thank you.
Thank you, Lauren.
Hi again. As I said, my name is Carrie Bradan. I'm a Skokie resident, and I'm here speaking tonight as the chair of the Skokie Alliance for Electoral Reform, the nonpartisan grassroots ballot initiative committee that crafted and circulated the electoral reform referendums that were passed tonight. We are thrilled to be here tonight to witness this official passage of these referendums into law. Skokie is on the cusp of a revitalized democracy, thanks to the initiative of James Johnson, whose historical research revealed that decades-old systemic barriers to entry into Skokie's electoral system could be eliminated, to the tireless efforts of Alliance volunteers, many of whom are here tonight, all across the village, who gave their time, talents, energy, and material resources to craft, circulate, and pass these referendums, to all the Skokie voters who participated in the election on the referendums and made their voices heard, and to the efforts of the village's implementation team to carry out these referendums with fidelity to their intent. With these reforms in place, we will have a more level playing field for all potential candidates for village board. We know that Skokie's abysmal voter turnout of 9% for village board races is not due to voter apathy, but rather to lack of choice on the ballot. With our new electoral system, we are excited to see ballots with more than one candidate running for each position. This will result in increased voter turnout, resident engagement, and responsiveness by those elected. When Skokie voters have reason to participate, we do, as evidenced by the incredible turnout at the mapping and implementation meetings the village held over the last few months. This is the beginning of a more engaged, dynamic civic community in Skokie. The Skokie Alliance for Electoral Reform plans to remain engaged in public education efforts to ensure that potential candidates and voters understand the new electoral system. Given the changes, we urge the village to please create a guide for potential candidates that outlines the new process for filing. Full transparency and increased candidate and voter participation can only be good for our democracy, and we hope the village will participate in educating potential candidates and voters. And to all my fellow Skokie residents, this is our chance to truly make every vote matter. Let's keep up the civic engagement that we've seen blossoming over the last couple years. Run for office, campaign for the candidates you support, and vote in 2025. Thank you.
Thank you. Trustee Sucker.
Oh, this one. Sorry, I don't have a comment, it's really just kind of a clarification point. I'm sorry if I'm beating a dead horse here, but going back to what our agenda item is gonna be about the Attorney General's determination letter, what exactly is going to be on the agenda?
I don't know yet, but it will be on the agenda.
Okay, then.
The item will be on the agenda.
Just to give the board a chance to be a little more specific, I do want to offer a motion that we will fully comply, since the determination letter is binding, and it's not asking for a discussion, it's asking for an action. So I move that the village board fully comply with the Illinois Attorney General's December 1st binding determination, and that we include our June 5th, 2023 closed session minutes on the consent agenda at our next regular meeting on December 18th for approval.
And that will be up to John, putting it on the agenda. There's no second, so the motion fails. But as I said, it will be on the agenda. Okay. Trustee Sucker.
I move we adjourn.
We are adjourned.